Hi, Daniel. It's nice to see you. How are you today?
Hi, I'm doing great, Christy. How are you?
I'm doing so well. Thanks so much for joining me today. I'm really excited to talk to you about all things real estate and the legal side of it.
Yes, of course.
Perfect. So please introduce yourself, introduce Anchor Attorneys, and explain a little bit about the kind of services that you provide to foreign buyers in the Riviera Maya.
Of course. So for our public and everyone that's watching, my name is Daniel Marin. I'm an attorney in the Riviera Maya, and I'm an attorney at Anchor Attorneys Mexico. And what we do is Anchor Attorneys is a legal firm, a law firm that it's specialized in real estate and corporate law. And in this case, we're going to be talking about real estate. So all about, buying, selling, everything regarding real estate here in this area, Quintana Roo, which is, basically the state where the Riviera Maya is. We do all types of transactions in Tulum, Cancun, Playa del Carmen, Acumal, all the Riviera Maya. So we're more than happy to help all your clients or the investments on the investors to acquire real estate in this area for sure.
Amazing. Thank you so much for that. And so let's talk a little bit about how a foreigner can buy property in Mexico, specifically in the Riviera Maya where you are. And let's talk a little bit about the main legal restrictions for
Right.
foreigners.
Of course. Yes, exactly. So as you say, there's kind of a restriction due to our Mexican legislation. So our Mexican legislation says that for foreigners to acquire real estate, they have to do it through a vehicle that it's a trust, or in Spanish called Fideicomiso. So residential trust, Fideicomiso residencial. That's the Spanish translation. So this, if you're buying within 50 kilometers from the coast and 100 kilometers from the borders. Of course, Riviera Maya, this paradise, really close to the coast for sure. And so this is the case. We have to constitute, or foreigners have to constitute a residential trust, a fideicomiso residencial, in order to acquire their properties, right? And to invest, of course. So that's like the main way. There's another way in this case, which is buying through a Mexican company, but in this case, we'll focus. We can do another video for that, but in this case, we
Right.
can fully focus in the trust, which is the natural way or the best way to acquire any properties or real estate in all these areas for sure.
Okay. Right. So the other way would be through a corporation. So we
Yes,
can talk
a
about that in
Mexican,
another video.
of course, yeah, for sure,
Oh, and
because
being a
it's a whole
Mexican.
other area, but yeah, for sure.
Okay, perfect. All right. So, how
Yes,
about you explain a little bit about what a fideicomiso is and who the
yes.
key players are in this process?
Of course, yes. So basically, the Fideicomiso is, again, the vehicle. So how it works is that you have a seller, which is, in this case, Tristor, is the person that's going to be transferring the units as the seller into the trust. You have a trustee bank, which is going to be holding your trust. And of course, you have the beneficiary or buyers in this case, right? So these are the three main characters of all this transaction. The seller will only transfer after getting paid, after everything is finished, after we complete the transaction, is transferring the unit and the real estate that you have invested and bought. The seller puts it in the trust. The trustee bank acts as the holder. They will hold the trust due to the Mexican legislation, and the buyer will have the full benefits. So
Okay.
benefits of gains, benefits of if it's going to be rented. If you sell the property at some point, you get the gains. So the bank, it's only the holder. One thing that's really important to know is that the only thing that can be put into that trust is the real estate, right? The property that you're buying. You don't put money. You don't share gains with the trustee bank. You have the full benefits. You're not buying directly under your name. You're buying through the trust, but you have the full benefits. Of course, you also have some obligations. You have all the rights, but you also have the obligations, like paying property tax and taking care of the property and all that. But
Okay.
you don't share these rights and obligations with the trustee bank. It's fully
Okay.
yours.
Great. Okay. So we've got the seller, the fideicomiso through the bank, the trust, and
Yeah,
then the buyer. So there are our main.
exactly.
All right, great. And so is this similar to the process of setting up a trust in the United States or other places?
It's more or less, we call it trust because it's the best translation we can give to the Spanish
Mhm.
word, which is fideicomiso. Yet it's not quite the same because, again, for example, it's my understanding that in other parts of the world, whenever you set up a trust, you can put something else than just property, right?
Okay, great. So
So in
just for
here,
real estate.
yes, just for the acquisition of the property, it's just like the authorization of the permission for you to be able to have rights over a real estate in this area, basically. So yeah, I mean, it could be somehow the same because you have someone that puts in the object of the trust, which is the seller. You have a bank that it's involved because, it's holding the trust, and you have yourself as a benefit. That's a beneficiary that gets all the benefit from whatever is in that trust, which is, the property. So it's more or less the same, but yes, we have some other components that we'll talk further in the conversation for sure.
Okay, great. Okay, perfect. And so, how does the bank play a role in this trust process?
Right. Well, the bank is really important because the bank is the one that is going to be holding the trust. And also, the bank is the one that will be getting all the notifications, all the permits, everything to the Ministry of Foreign Affairs. Because the ministry, as a part of the government, has to know, who's buying, what he or she is buying, and all that. So the bank will help you out with all that, will hold that trust. And for that means you take care of an annual fee, and yeah, you cover this payment or this fee for the bank to be able to hold the trust and get everything, all the communication with the government, with the ministry, saying, here is the beneficiary, this is the object of the trust, everything's going well, and all that.
Okay.
So it's actually a main character of the trust. Yes.
Right. So that's where all the legal communication kind of comes out of.
Yes, most of it. Yes, exactly. You
Right.
basically let the bank do all the communication and all the notifications and all that, and you just get all the benefit. Yeah.
All right, great. And so, what are the legal benefits of having this trust set up for property ownership in these restricted areas that are 50
Right.
kilometers from the coast?
Of course, it's really secure. It may sound as not proudly, but it's really, really secure. I mean, at the end of the day, again, you have the full benefit of, you have the full rights of everything, but still it's under a trust. It's under something that it's not the bank, it's not the seller, it's not the buyer, it's the trust per se. So it's kind of, it has like an armor that protects the property from any legal circumstance, and yet you still have all the benefit of that. So it's really safe. This whole trust thing and situation, it was done because, prior to that, people tend to buy through a Mexican person, like saying, hey, I have a friend, or I know someone, hey, help me buy this. I put it under your name, but it's mine. I'll pay it. I get everything done. But then it was of course fully dangerous because, the other person, it was under its name, the title, it was under the name of the Mexican person or the friend or someone who the investor knew. And of course, whenever it comes to selling or everything, one that has the title is the one that has the rights for it. So yeah, so instead of doing that, instead of needing to have the trust in someone that you can actually do it through him or her, you can do it through the trust, and that's the best way. There's a lot of horror stories through that path. So the best way and the more secure way is doing to the residential trust for sure. So yeah, it's really secure.
So this is the safest way for a buyer.
Yes, for
in
sure.
Mexico. All right. So I'd like to ask you next, what steps should a foreign buyer take to make sure that the legal status of the property is legitimate? So for example, how do we make sure the seller is the rightful owner of the property, and also that there are no liens or other legal issues with the property they're looking at?
Yeah, totally. So basically in the anchor attorneys, we have a 5-step process, right? And we do this in a 5-step process to make sure that from the beginning of the process till the end of the process, we have, full security and legal security, and we have peace of mind that everything's going to be all right. There's nothing that can jeopardize the transaction in any stage, and the investment is, fully secured. So the first thing that we do is a due diligence. Okay. So in Mexico, we have a public registry of the property, right? specifically in Quintana Roo, what we do is that we go into that because different from the States, Canada, and any other part of the world, we don't have title insurance companies. So our insurance, we have it like the substitution of title insurance company are two things. One, the public registry, and two, the notary. Okay. So what we do is that the public registry has all the database, has all the recordings of everything, every single thing that has happened with the real estate. Okay. So we go into that, we go into the records, and we get into, the legal background of the property that you're buying. Now, if we have, let's say, a pre-sale and there's no building yet, there's no specific apartment, or there's no specific house yet, it's going to be constructed, but it's not there yet. It's not a problem, because what happens is that the seller should have the ownership of the piece of land, the lot where the project is going to be built. So we can go into the legal background of the piece of land just to make sure exactly that. For example, the seller is actually the owner of the property where the construction is going to be built, where all the projects is going to be set. Now, also, there's no liens. There's nothing that can put, there's no skeletons in the closet. There's nothing that can put in jeopardy your or the investment of the investor, the buyers, in the near future. So we do that, we get that diligence done. We go to the public registry, we go into the records, we see that, we get all the information that we can gather from that. And we put that all the information, we break it down, of course, in an easy reading, into a report, and we send it to the clients. That's a way we can make sure that, it's a legitimate ownership. There's no liens. The piece of land, the lot, is not part of a trial or something that can have complications in the transaction, can make things not good. So that's actually the way we can make sure with the due diligence. So we go into the public registry. Now, that's regarding the piece of land. We always also do another research regarding who's going to be selling. So there's some stuff that it's public. There are some things that are private. For example, all the numbers or the the financial situation of the companies, that's private. But what we can make sure is that, for example, if the company that it's the seller is actually recorded, it's there, it exists. It's a legitimate document, legitimate articles of incorporation. It's, and also we can make sure that in that articles of incorporation, there's a clause with the faculties and the powers of the person that it's representing the company. And this person has the powers to sign the contract first, and later on the deed or the title of the property under your name, or the trust. So we make sure that everything's there. Also, all this information, we put it into the report and we send to the clients, just to make sure that we have, really legal security for the full process of the purchase.
Perfect. So it's really important to get this due diligence done to avoid any potential hurdles or delays in the purchase process.
Yes. Most of the horror stories that you can hear about is because they didn't get the due diligence done. Yes.
Guys, get your due diligence. Make sure you're working with someone reputable. Okay.
Yes, for sure. Yes. It's really important to get a due diligence. That's where you can see the red flags that you can see, if you have to be concerned about something or not. Now, also to be said that there are some liens that are not, that are not dangerous. There are some builders get structures done. For example, they get a real estate trust or an administration trust to get, bank involved, that they're supervising, that everything goes right. And that's not a lien per se, but that's like protection for both sides, of course. Most of the part for the buyer, because there's a bank involved, there's someone that is supervising that the construction is doing well, and it's going to be, delivered. So there's liens that are not, that are not dangerous. There's liens that to be concerned about, of course, but this due diligence shows all of them. So we can see, like saying, okay, they have an administration trust, which that's perfectly normal. That's perfectly fine. It's going to be partially extinguished whenever we get to the closing, or we can see that there's there's a lien, they have a credit that it's not paid from 3, 5, 10 years ago, or the property is an object of a trial, whatever. We can see that, and we can make sure that the investment is safe. Yes.
Perfect. Great. Okay.
Mm-hmm.
And so once the due diligence is complete, what would be the next steps in the buying process?
Of course. So once we have that and we have peace of mind that everything is correctly done and ready for moving forward, we review a contract. So this before, whenever you buy in a pre-sale, even in a resale as well, you don't actually get the title right away. So there's a document that has to be signed to protect you from the moment that you put some down payments through all the process, all the way to the moment that they actually deliver you the property and they sign off the title of the property, right? And in that document, it's called promissory contract, all right? So to go a little behind of the process, I think I didn't say this, but there's 3 main documents that you have to sign. First and foremost, the offer letter. That's when when you get the serious, you confirm the seriousness of the purchase, right? The intention of saying, okay, I'm going with this property. I'll put in a reservation and we'll look into all the paperwork. The second big document that you have to sign is the promissory contract, that we're going to talk about it right away. And the last but not least document is the deed or the title of your property, which we'll talk about further in the conversation. Now, the promissory contract, it's the following step after due diligence, right? And the promissory contract brings to the table all the terms and conditions of the actual purchase, delivery date, closing date, all the specifications of what is it about, if it's furnished, your property is going to be furnished or not, dimensions, the project itself, terms and conditions regarding, for example, what happens because of breach, non-compliant clauses, percentages of penalties, all this kind of stuff. It's going to be there. It's going to be shown in the promissory contract. So what we do is that in this second step, we review the contract. So we make sure that you have a solid contract. We don't go into, us specifically as your lawyers, we don't go into, purchase price payment methods. That's something you've already handled alongside with Christy and negotiated with the seller. But we do go into, penalties, dates, percentages, all this kind of stuff. We go into just to make sure that you have a fair contract and it's a solid contract so you can move forward and all the obligations, all the rights are determined, established correctly in the contract. So, just as a prevention kind of way in moving forward with the full process. So that's what's the legal backup, your contract. That's why we review it. So the following steps would be the review of the promissory contract in order to sign and move forward with the transaction.
Great. Okay, so when we're talking about contracts, we're here in Mexico. I'm just gonna put it out there. Is the contract going to be in Spanish or in English? And how do we review the contract as perhaps someone who doesn't speak Spanish very well, just to make sure that it's legally sound for the person purchasing?
For sure, yes, definitely. No, I mean, offer letters, and that's a really good question. Offer letters and promissory contracts, normally due to this area, foreigners buying, normally are 99% of the time, we have a 2-column contract with Spanish and English version, right?
Great. Okay.
They developers and sellers, lawyers, in case it's a resale, try to get the best translation done from the Spanish to the English version, because the one that will prevail will be the Spanish version. Again, That's why we also review it. But yes, you'll have a 2-column contract, a 2-column document where you can see a Spanish version and an English version. 99% of the time. I've come, of course, to some transactions where developers, they just have a Spanish version, which it's going to be signed. That's perfectly fine. We'll take care of the translation. So the buyers are in perfectly understanding of what they're going to be signing, what are the terms and conditions. Again, we review it prior to the signing, of course.
Right.
But yeah, 99% of the time it's Spanish, English version for the two out of three documents, which is offer letter and the promissory contract. Now,
Okay.
the deed is going to be Spanish, and we'll talk about that further in the conversation. And
Okay.
it's not just because it has some explanation for that. Yes. But yeah, the contract's going to be Spanish, English version.
Great. And so, are there any specific legal clauses in these contracts that the buyers should be aware of when they're going through the purchase contract?
Yes. There's some specifications that it's my understanding after various years in this area that it's not quite similar to States or Canada.
Right.
So basically, the main things that you have to be aware of is, well, contracts are divided into declarations and clauses, of course. Now, declarations is basically, establishing who are the parties, the object of the contract, and all that. Now, the clauses are the main terms and conditions. Now, there are some clauses that they don't actually are similar to, again, to States or Canada, where, for example, in this area, we have something really common, which is a period of grace. So what happens? We have this time frame that it's given in good faith from the buyer to the seller. It's an amount of time for the seller to be delayed due to situations that it's not under their control, yet they don't come in as an act of God or force majeure. Some situations that they cannot contemplate. It's, I don't know, example, it can be, a week instead of 1 or 2 days of a really heavy rain, a week, a full week, or 2 weeks, they can be plenty of things. Also, for example, delays on the delivery of materials, because we're way in the south, we get things from probably the north of Mexico or the southern part of Mexico. So everything has to be shipped to this area. So the shipping part sometimes, takes a little bit more, and it's basically some stuff. In this period of time, it's in good faith for things that they cannot control, they cannot contemplate prior to things happening, but it's not a force majeure nor an act of God. So that's a normal clause that we establish in contracts. It's pretty standard. For everyone not to be surprised when they see it, it's pretty standard, and it makes sense. It totally makes sense. But yeah, it's my understanding that you don't see this in the States or in Canada. So yeah, that's one of the clauses that it's mostly asked what's it about or what is it doing there. Yeah.
Right. Okay. All right. Great. And so we're at the point now, the contracts are signed. How can we make sure and enforce the seller's obligations to make sure that we're going to have a smooth transaction?
Of course. Well, the contract is your as a buyer is the main document to be protected, fully protected. That's why we actually make sure you have a solid contract, and also we have to make sure that it's correctly signed. So normally there are plenty of investors that they get all the transaction done overseas, right? They come 1 or 2 times, maybe. They check out properties and they say, okay, I want this one, but they finalize the transaction overseas. They go back home and say, okay, I like this one, and the offer letter, it's signed and delivered from back home, and everything is done from the distance, right? So there's 2 ways to sign. If you're here presently, you can sign, wet signature, and you can deliver the contract. You can take back home your original as well, and you'll sign physically. But if it's not, if you're doing everything overseas, what's the proper thing to do is digital signature. But the digital signature has some requirements for this contract. Okay, so there are some. In our legislation, we have some requirements. We have a certificate that we make sure with that certificate that it's the email given, it's a person that will be signing. We can do it from different applications, and Builder most of them there are some that still do it the old way, which is printing, signing, sending it through shipping, and then getting it back with the wet signature. But there are some others that have, updated with all this new technology, and we can do digital signature. So whenever the contract is ready, we make sure it's correctly signed so you can enforce in case of something happening. We have mediation in case something goes, sideways. We have since 2018, we have new ways to not necessarily go to trial, because many people are, concerned if something goes sideways, what can we do? And we can enforce through mediation. We can volunteer, say, listen, we want to mediate and all that. We don't expect that to happen. It's not common. It's really uncommon. Sometimes builders, they take their time to deliver, but it's uncommon for them not to deliver. Like it's rare. It's really rare, to be really honest. I mean, I think you can count cases. It's not much. And I mean, it makes sense, because at the end of the day, it's not business for them not to deliver, because it's, bad fame and publicity and marketing. It's really bad. So they don't sell anymore, and it's not good business for them. So, so they try to, compensate if they're delayed. They try to compensate it anyway, economically or with, upgrades and all this, if they're delayed. But they try not to be. We had some delays last years due to the Mayan train, due to the big government construction that we had. So all the manpower went. Yes, the train Maya, yes, and we have the new Tulum airport as well. So, but other than that, we're good. I mean, it's rare for builders to not deliver, or to just fool around and with the projects and all that. It's not like that. Sure. They're really serious, and of course they in case they for any reason delay, they try to compensate in any way, for sure.
For sure. And that's the importance of working with someone like myself and Horacio, is making sure we do our due diligence on the developer as well, to make sure that they're reputable. All right, great.
Exactly. Mm-hmm.
So, all right, so we're at the finalization step here. So once the trust is set up, we've signed our contracts, what's the next step from here?
Of course. Well, after signing contract, depends on whether you're buying a real pre-sale or a resale.
Right. Okay.
If you're buying our pre-sale, after we sign the contract, we've signed, depends on whether the construction is ready or not. So this is what happens. So we sign the contract, right? And in the contract, you have a delivery date for a year, year apart or 1.5 years, whatever amount of time, but it's not immediately. It's not ready to be delivered. The construction is not yet there, right? Okay. So in this kind of situations, what we have to do is that we have to wait for the construction to be finished, because the next step after signing the contract is to set up the trust. Now, this is the situation. In order to set up the trust, we need something that it's called condominium regime. So the condominium regime is a public deed that it's gonna be delivered to us or shared to us by the builder. They have to get all, everything done regarding licenses, permissions, documents, all the paperwork. They have to get it done. Go to a notary, all these things, they get it done. In order to get, as a result, this document that's called condominium regime. And in this document, we'll have the full official description of the project, like the full project, meaning whatever they, any units that they've built, or let's say 20 units, the description of all 20 units, meaning measurements, surface, also common areas, of course, all these full specifications regarding the project. That's the official document. Like, that's the actual document that's going to be recorded in the public registry, and it's official document to identify the unit that you're buying. Okay. So once we have that, well, the seller or the builder has that, and they can share with us, then we can start with the setup of the trust. Because in order to set up the trust, we need a permit. The buyers, regarding, going back to when we started our talking, due to Mexican legislation, due to the trust, we need communication with the Ministry of Foreign Affairs for permission to set up the trust. So the Ministry of Foreign Affairs asks us to identify, one, who's the seller, two, who's the buyer, and three, what's the object of the trust, which means what are you buying? What are you putting into that trust? Now, you identify the seller with the articles of incorporation, with the ID of the legal representative and all that. You identify the buyer with their passport, driver license, and all that. And you identify the property with the condominium regime. That's why we need that, because that's the official description, that's the official documents. So whenever we have that, we set up the request for this permits. We send it to the bank. The trustee bank will gather all the documents, all the information, and we'll approve. We'll say, okay, they'll review everything and we'll approve to hold the trust, and then to send all the paperwork to the ministry for the permit. Once the permit is given and is issued, then we can move forward with the actual closing. So basically, just to make a brief summary of what's happening after the signing of the contract, we need to wait for construction. Then we need to wait for the condominium regime documents, and then we set up the trust with the permit of the Ministry of Foreign Affairs and the trustee bank. That's how it happens. After that, we have some other, two remaining steps, but just to make sure that I answer your question, that's what happens after the signing of the contract.
Okay, so that's for pre-sale. And so for the already ready
Resales.
To deliver properties, the resale, how does that work?
If it's ready to deliver, but still is coming from a builder, we still consider it as a pre-sale. The only difference is instead of waiting, a year to get the construction, for them to get the construction done, we had all the paperwork already, so we start working right away with the trust and all that. Right. Now, the difference with a pre-sale with a resale is that whenever it's a resale, you're buying from a person that probably most of the times, they have already a trust set. So they set up their trust, and now they're just, they have the ownership, they have the benefits of the trust. So that's different because we don't have to set up a new trust. What we do is that we just make sure that the trust is viable, it's useful for the buyers, just to make sure that maybe what we can do is that instead of setting a new trust, we can acquire that trust, and that will be that's something that we call assignment of rights. So we take out of the old the original owners, and we put in the new owners.
Okay. All right. Yes. So there can be like a transfer of the trust or an assignment of a different owner. Okay. Exactly. Perfect. All right. So are there any other steps involved that we've left out? Like we're sort of getting to the end of the conversation. Do we have our keys in our hands yet?
Yes. Well, that's actually a good thing. You came out with a really good thing. So just to make sure, there's two momentums when it happens a lot whenever you're buying a pre-sale. There's two momentums to know about this process. There's physical delivery, right? Okay. And legal delivery. Right. Now, this normally, or we aim for it to happen at the same time, like the same day. For example, having the physical delivery, 9 a.m. of the morning, and having the closing and signing and everything at 2 p.m., something like that.
Right.
But to be really honest with you all, due to many situations, sometimes or most of the times, it doesn't happen at the same time. Okay. This is what happens. So builders, they get the construction done, right? They get everything done. They have the project, units are ready. They're fully furnished. They're fully finished. Common areas are there. Everything's there, right? But the thing is, if you may remember about the condo regime, the construction has to be finished in order to get the condo regime, right? And the builder has to do a lot of paperwork, a lot of diligences, and a lot of, I call them bureaucratic processes. with government institutions in order to get the document, the condo regime, and move forward with closings and the setup of the trust and everything. So from the moment of the fully finished construction to the moment of the condo regime, sometimes you have a difference of a month or, like 6-7 weeks. Okay. So in that amount of time, you already have a unit ready. You already have, the project ready to deliver. So what happens is that the builders offer to deliver the properties prior to closing, which it's totally valid, it's secure, it's legal, you can do it. And you can take possession, which means you're delivered with the keys. This is what happens. You set up the date, you schedule the date for delivery, you get a walkthrough done, review that everything as it is as promised, and then you take possession. They give you the keys. They say, okay, you can start living in it. You can start, I don't know, if you want to put some other furnish, I don't know, whatever you decide to do, you can start doing whatever you decide to do with the property. Okay. But the closing is going to happen in a few weeks. So that's
a legal delivery we're waiting for. The physical delivery is done. We're waiting for the legal. So that can be 6 to 7 weeks later.
Exactly.
Okay.
Yes.
Okay.
Now, that's what happens. So they deliver and then we get the closing. Now, once we have, going back to the legal process, once we have the permit from the Ministry of Foreign Affairs, we move forward with the closing, the actual deed, the actual title. Okay. So the legal delivery. So what we do in this step is that we involve a notary, because in Mexico, notary publics are the correct people to formalize real estate transactions. Notaries have some obligations towards the parties, like, for example, regarding the buyers, they have to take care of the payment of the taxes regarding the purchase and pay all the taxes on behalf of the buyers. Of course, notaries will give all the receipts of payments and everything to the buyers once they get everything paid. Another obligation is that the notary, and that's why, if you may remember, I said the notaries kind of work as a title insurance company, because it's not exactly that, but it's kind of, because they get the deed recorded in the public registry. The notary is the one that it's obligated to get the deed recorded. So whenever you go back or you want to sell, whoever gets the due diligence done, he or she can see that it's yours, right?
Right.
So what happens is that we get a notary involved, and we ask the notary to formalize the transaction. We send all the paperwork, seller's paperwork, buyer's paperwork, the trustee bank, the permit from the Ministry of Foreign Affairs. We send all the terms and conditions, how much the buyer paid for the property, all the wire confirmations to confirm that everything is paid, everything. We send all the paperwork to the notary. The notary will draft a deed, the title, and we'll meet with the notary to sign the deed. So the seller comes in, the seller's representative comes in, the buyers come in, and they sign the deed. And this is how it works. Once it's signed, fully signed, the notary has, it's not an obligation, but they normally take around 5-6 days, more or less, to issue a certified copy. Okay. This is really important because it's a certified copy. It's not the original. The original, like I previously said, it's going to be sent to the public registry. It's going to be recorded. And once it's recorded, the public registry will send it back to the notary with something that I like to call recording certificate, which is a document that confirms that your deed has been recorded. Okay. Once they have that, then they'll give you the original, because an obligation is to give you the original with the recording certificate and all the receipts of taxes being paid and all the information and everything, all the documents that you share with the notary. It's going to be there. It actually comes in as a little book like this thick, because it's a lot of papers. Like it's it's a lot. So once that's finished, then you have your original. Now, from the moment that you sign your deed to the moment that you actually get your original, it takes about 4 to 6 months, more or less. And you say,
Right.
wow, that's a lot of time. Yes, it's a bureaucratic process, to be really honest with you. The public registry takes a lot of time to get things recorded and send it back. Now, no worries. First of all, you're not going to be empty-handed for the full 6 months. You'll have your certified copy, which, remember, it's going to be delivered to you in a physical or digital way. Digital version sent by email, physical, you can, it's going to be hand in. If you're here, send it by shipping through us or whatever you need. But you'll have a certified copy through the full 6 months. And it is secure because once the notary sends it to the public registry, they cannot get anything else recorded until they get that recorded first. So it's really secure. So it's not like it's not in the limbo waiting. No. It's there, but the public registry takes their time. It's like they're really careful with what they get recorded, so they take their time. I want to think that.
Yeah, right. Okay. So does that mean the legal delivery is confirmed once you receive the certified copy, or do we need to wait the few months for that to be like finalized?
Let's say that it's completed when you receive your certified copy.
Yeah. Okay.
But let's say that you formalize your transaction with the signing of the deed. It's completed with the certified copy, and it's perfected with the original coming.
All right, great. Okay, all right. Mm-hmm. And so I have one last question for you in regards to the process. So you were talking about, doing the final walkthrough and, a lot of these purchases are actually going to be out of country. Is it a requirement for the buyer to come to the property to do the handover, or can you have a representative come or organize that on site?
Of course, yes, you can actually have a representative for both things, for the delivery and for the legal, for the signing of the deed. For the delivery, depends on the builder if a notarized POA is needed or a simple POA. For the legal closing, for the legal delivery or the closing, you actually need a notarized POA. In cases, if, for example, they already know, buyers come down, they look into properties, they say, okay, I want this one, I'm gonna, and to be really honest with you, I'm not gonna be coming back. I don't know. Let's say delivery and closing is gonna be in 6 months apart from from the moment they agree to buy the property. So to be really honest with you, I'm not gonna be down here again in 6 months. So now that I'm here, I can leave a POA signed. So with a local notary. That's one option. Second option is I just went down, looked into properties, everything good, but I didn't decide a property, so I went back home and now I have that. But I'm not gonna be down there again in 6 months. We can do a POA, send it, but instead of a local notary formalizing or stamping the POA, it's gonna be done overseas. So we'll send all the instructions in order to get it done correctly because there are some requirements to fulfill, and then send via shipping so we can, as lawyers, we can represent and sign the deed on behalf of the buyers. Yes. Now, yes, you can be represented, but I normally recommend that for physical delivery, not legal because it's just documents, but for physical delivery, they do come to, receive their property. At the end of the day, to be honest,
beautiful new property. Yes. Come back to Mexico and be the first one to walk in as the owner. Yes. All right, I love that.
Yes, I think, after all, whatever time, even if it's a month or if it's a year, whatever time you took and waited for your property to be delivered, I think, whenever you receive the property, there's, this joy and this good feeling of receiving your new property in this paradise. And also, I always say to my clients that beauty is subjective. So maybe through my eyes, I can see that everything is fine, correctly put in, everything is done as promised. But through the owner's eyes, which is the one that is buying the property, it's going to be their home, their new property. It's not correctly done. So I think it's better whenever they come down, at least for the physical delivery. The legal delivery, it's just signing, it's paperwork. We can do that for them. But for the physical delivery, I highly recommend that you come down.
Yeah, go do the walkthrough, make sure you're
Of course.
happy and make sure everything's good. All right, great.
Yes,
So,
exactly.
is there anything else potential buyers should know before starting the purchase process here in Mexico?
Well, I think, I just, yeah, I think I forgot to say that the deed is gonna be in Spanish, and
Oh,
this is due
yes,
to
you
our
mentioned that.
legislation. Yeah, I think I forgot to
Right.
say that. So the
Yeah.
deed is in Spanish. Nevertheless, of course, our team of lawyers or myself, if it's my possibility to be there, or any of our team members will be there assisting and translating everything. Like explaining the full deed, the full content has to be in
Right.
Spanish because it's one of the requirements of due to our legislation. So
Okay.
the deed's gonna be in Spanish.
Right.
Purchase price, even if it's set in USD, we have to have a value in Mexican pesos.
Right.
So
Okay.
you will see in the deed, the final document, you see you set up for whatever amount of dollars to buy the property, but that amount of dollars makes some amount of pesos. So you'll see two amounts,
Okay.
USD and the Mexican pesos. So Spanish, USD, and yes, that's the deed cannot be signed electronically. That's the only document that you cannot sign digitally. Has to be wet signature, and as we already explained, it can be through a POS.
Okay.
Now, other than that, to be really honest with you, I think horror stories come from not having a good team by your side representing you. Like in the commercial way, of course, in this case, Christy, of course, that have the full experience, knows what is the best investment, which property makes sense and it's good for investment. And on our side, on the legal side, of course, a lawyer. If it's us, better, of course. But yeah, have a lawyer by your side, have a real estate agent by your side. It's the best way to buy in a secure way.
Yeah.
Hire professionals. That's how it's done.
That's a good message. Yeah, I think with any big purchases, we really want to make sure we have the right
Yes,
people on our sides. Real estate agent, your
yes,
attorneys, and the notary as well. So
of
making sure
course,
you do your due diligence not only on the property but also the people that you're going to be working with. So it's really,
exactly.
yeah, that's really great advice. All right. So is there anything else you'd like to add? So maybe something about what clients can expect if they work directly with you and anchor attorneys?
Of course, we'll try to. Well, I just like I just said, I try to, and everyone in our team, we try to make a really good team with, because again, commercial side, we try to be experts in our area. So we leave the experts in the commercial side, real estate agents. We try to make sure to do a really good team with in this case, Christy and a real estate agent. We try to make a really good team to, provide the best service, the best personalized service, whatever the needs of the client is. We try to make sure that they have peace of mind and that the process is, joyful for them, maybe stressful for us, but they get the full joyful experience. But yeah, I mean, other than that, any questions? I love talking about the process. I love talking about any details. Any questions? You can contact Christy. We can set up a video call, a phone call, and we'll talk about anything all your viewers could any questions could have.
Perfect. All right. Well, thank you so much for your time. It's been a
My
pleasure
pleasure.
learning all of the little intricacies on the buying process and, yeah, learning what to look out for as well. So, thank you
Great.
so much for your time. We'll talk soon.
Yeah, thank you for inviting me. It's my pleasure. Have an excellent one.
Absolutely. You too.
All
Bye
right.
bye.